unconstitutional, it is not eclipsed by fundamental rights. The law itself is dead ab initio. The law itself is dead ab initio. Clear? Understood this idea? However, later on in the Shri Ambika Mills versus the state of Gujarat case, the Supreme Court extended the idea of doctrine of eclipse also to post-constitutional laws, which means as of today, any law that is enacted by the enacted by the parliament or enacted by the state legislature but has been declared unconstitutional or ultra vires because it is contradicting fundamental rights, it is not consistent with fundamental rights, in that case the law becomes a dormant law, which means the law is not enforceable. The law is not enforceable. The law exists, still exists, but the law is not enforceable till the point it is inconsistent with fundamental rights. If it so happens tomorrow that the fundamental rights, the eclipse that has been caused by that fundamental right is removed, how? By a means of an amendment to fundamental right. In that case, what happens is that now it becomes enforceable. Now it becomes enforceable. Further, see why doctrine of eclipse? Why not just declare it to be a dead law? The reason is that people who are residing in India, not all of them are citizens of India, which means not all individuals enjoy fundamental rights. All these fundamental rights that are there, these are available only to citizens, not to non-citizens. If you remember Article 15, Article 16, Article 19, Article 29, Article 30 of the Constitution, I have specifically said that these are not given to non-citizens, these are only for citizens. So all these fundamental rights that we have, these fundamental rights are not applicable to everyone. So even if there is a law that is enacted by the parliament which is contradictory to, suppose, Article 15 of the Constitution, and it has been declared to be unconstitutional by the Supreme Court, because it is a dormant law, it would be a dormant law for whom? For only those individuals who have fundamental rights. But some individuals who are not extended the same kind of protection as it has been extended to citizens, for them those rights, those laws are still applicable. If you declare the law to be a dead law, which means now it is dead, it is not applicable to citizens, it is not applicable to non-citizens. But in this case, not all fundamental rights are available to non-citizens, which means if you declare the law to be dead, it is not applicable against non-citizens as well. But once you declare the law to be dormant law, now what happens? It is not applicable only to citizens, but those who do not have the protection of fundamental rights. Those who do not have the protection of fundamental rights, for them the law is still enforceable. For them the law is still enforceable. Like, if you remember, we were talking about something called as Section 66A of the IT Act of 2000. Now, Section 66A has been declared by the Supreme Court to be inconsistent with freedom of speech and expression. But this freedom of speech and expression is not available to foreigners. That is only available to citizens. So, if there is a foreigner who comes out with any such contradiction, if he contradicts Section 66A, in that case he is punishable under the law. Because this protection of Article 19, freedom of speech and expression, has been not extended. This has not been extended to foreigners. It is only extended to citizens. But if you declare the law to be dead, what happens? The law is not applicable also against foreigners. And that is the reason why the Supreme Court has come out with the idea of doctrine of eclipse. If you are not applying, or if Section 66A is declared to be a dead law, in that case don't you think the protection of freedom of speech and expression, this right, this fundamental right which is only there to citizens, it's not there for foreigners, it's only there for citizens, isn't it automatically extended to foreigners as well? Yes, it will be automatically extended to foreigners as well. If you do not come out with, if the Supreme Court did not come out with an innovative interpretation and by extending this idea of doctrine of eclipse, in that case what would have happened? What would have happened was that these fundamental rights which are only available to citizens and not to all, automatically there would be extension of these fundamental rights, and these fundamental rights would also be available to those who should not have enjoyed these fundamental rights. And that is the reason why doctrine of eclipse. Have you understood this idea? So there are three cases here: the Bhikaji Narayan case, the Deep Chand versus the state of UP case, as well as the Shri Ambika Mills versus the state of Gujarat case. Understood this? हाँ. Now someone was asking something, कुछ पूछ रहे थे, इसीलिए मैं बोलता हूँ अंत तक रुको. So this is what is doctrine of eclipse. Have you understood the idea of what doctrine of eclipse is? Eclipse, you know, like the geographical phenomena of eclipse कैसा होता है? जैसे हम मान लो solar eclipse की बात करते हैं. So solar eclipse, what happens? The moon comes between the sun and the earth, and that is the reason why till the time that that is present, we find suddenly there is absence of sunlight. But does that mean that sun is no more present? No, sun is there. It has just been eclipsed by the moon. Similarly, the law is still present. It has just been eclipsed by fundamental rights. And this eclipse, this fundamental right that is there, it is not available to all. It is only available to citizens, which means this eclipse would be there only for citizens, not for non-citizens. So for them, that law, it would be still applicable. One more thing before, so that you are absolutely clear about it. The laws that are made by the parliament, it has extraterritorial jurisdiction as well. मतलब क्या है? You must have thought about this idea that why would a foreigner be punished under Indian laws? If he is a foreigner, so he will not be punished. He may not necessarily fall under the jurisdiction of ordinary court. No. If you are a foreigner, if you are not an Indian, if you are you are not the citizen of this country, but you are residing in this country, in that case you are still punishable under the laws that are made by the parliament. This is what is meant by extraterritorial jurisdiction of laws. I suppose I am an individual who is not a citizen of this country, but if I perform an act which is violative of a law, in that case I can be punished in this particular country itself, until unless I have immunity. जैसे diplomatic immunity होता है. So in that case, if you are a diplomat, you cannot be punished under that particular law. But otherwise, if you do not enjoy immunity, in that case you can be punished under such laws. So if you are a foreigner, but you are residing in India, if you have come to India, if you have performed a particular act which is not legal, which is a violation of a law, in that case you can be punished. You will be punished. You are under the ordinary jurisdiction of an ordinary court in India, which means you can be punished under that particular law. Clear? Now have you understood what is doctrine of eclipse? Yes. That for there, when an individual is not in the country, in that case there is no jurisdiction. Your laws do not have jurisdiction in other countries. If the individual is present here in India and has violated the law of the land, in that case the individual will be punished. Clear? Have you understood this? Write down doctrine of eclipse. Article 13 clause 1. Article 13 clause 1 states any pre-constitutional law, any pre-constitutional laws, I know, ठीक है, इतना एब्सेंट माइंडेड नहीं हूँ मैं, मुझे पता है कल मैंने यहाँ लिखा था, सम ऑफ यू हैव नॉट रिटन दिस, ठीक है, तो मैं किसी एक को नहीं देखता हूँ, आई एम लुकिंग एट एवरीवन, ठीक है. आर्टिकल 13 क्लॉज 1 स्टेट्स दैट एनी प्री कॉन्स्टिट्यूशनल लॉ that violates one or more of fundamental rights, one or more of fundamental rights are unconstitutional and void, are unconstitutional and void to the extent of their inconsistency, to the extent of their inconsistency with fundamental rights, with fundamental rights. The Supreme Court in the Bhikaji Narayan versus the state of MP, the Bhikaji Narayan versus the state of MP 1955 case, 1955 case held that all such pre-constitutional laws that violates one or more fundamental rights, one or more fundamental rights are not dead altogether, are not dead altogether, but they remain dormant by applying doctrine of eclipse, by applying doctrine of eclipse. The court clarified that as long as they clash with fundamental rights, the pre-constitutional laws come under the shadow cast by fundamental rights and remain eclipsed by fundamental rights. Fundamental rights and remain eclipsed by fundamental rights. However, by means of an amendment, if the shadow is removed, by means of an amendment, if the shadow is removed, they automatically become enforceable. Next paragraph. Also these fundamental rights are only available to citizens and not all fundamental rights are available to non-citizens. Therefore such laws are still enforceable against those who do not have the protection of fundamental rights. The protection of fundamental rights. Next paragraph. The Supreme Court in the Deep Chand versus the Supreme Court in the Deep Chand versus the state of UP 1959 case held that the doctrine of eclipse is only applicable to pre-constitutional laws and the post-constitutional laws under Article 13 Clause 2 is void ab initio and they are stillborn laws However, in the Shri Ambika Mills versus the state of Gujarat 1974 case, the Supreme Court overruled its earlier decision and extended the doctrine of eclipse to post-constitutional laws. Clear? This is all about doctrine of eclipse. See, in the upcoming week test, you are going to get a question on Supreme Court's role, the role of the judiciary in innovative interpretation of the Constitution. And in this case, you can always include the idea of doctrine of eclipse. In fact, if you remember, based on our previous discussions, if we go even to the discussion on separation of powers, the idea of separation of powers. Now, in India, the Constitution of India, nowhere there is any provision with respect to what you can say checks and balances. The term checks and balances has nowhere been mentioned in the Constitution. Yes, it is an implicit idea. You give the Parliament power to enact budget and power to enact laws, etc., etc. Similarly, executive has certain powers. Similarly, judiciary enjoys the power of judicial review, etc. So yes, implicitly the idea of checks and balances has been a part of Indian Constitution. It is a part of Indian Constitution, but nowhere explicitly the term checks and balances have been mentioned. But go back to our discussion, and we did say the Supreme Court has declared that this is a part of the basic structure of the Constitution. It has been declared by the Supreme Court. So from time to time, you will come across various interpretations that the Supreme Court has come up with, and they have extended various ideas which are not explicitly mentioned in the Constitution of India, and they have picked up various provisions from jurisprudence of some other country or certain some innovative interpretation of law, and they have extended it to the Constitution of India. And this is how the Supreme Court or the judiciary has contributed to the, what you can say, evolution of Indian Constitution. Clear? One more example of it is when we talk about something called as amendability of fundamental rights. Give this subheading: amendability of fundamental rights. Amendability of fundamental rights. Can anyone repeat what has been mentioned under Article 13 Clause 2? What is Article 13 Clause 2? Yes. Post-constitutional laws. Yes. Unconstitutional and void. They are to be declared null and void. Yesterday, you had written this idea. Article 13 Clause 2, which said that any post-constitutional law which is inconsistent, contradictory to fundamental rights are unconstitutional and therefore null and void, which means it is not enforceable. Going by the literal interpretation of what Article 13 Clause 2 has to say, can we say fundamental rights can be amended? Just look at the literal interpretation of Article 13 Clause 2 and then try and see that if there is a constitutional amendment bill which proposes an amendment to the Constitution whereby it proposes that any of the fundamental rights that are available, it needs to be changed, or it needs to be amended, or it needs to be done away with. If you go by this literal interpretation of Article 13 Clause 2, can fundamental rights be amended? Answer is no. Because Article 13 Clause 2 says that if there is a post-constitutional law and that post-constitutional law is contradictory to fundamental rights, in that case it's not enforceable, it is null and void. So any constitutional bill which has to amend fundamental rights will obviously be contradictory to fundamental rights. So if there is right to property and if we need to take away the right to property, in that case the constitutional amendment that we propose will be contradictory to the fundamental right to property. So if you go by literal interpretation of Article 13 Clause 2, it simply means that fundamental rights cannot be amended. Fundamental rights cannot be amended. So Article 13 Clause 2, what is the meaning of Article 13 Clause 2 was, it was something that was challenged in the Supreme Court. Supreme Court wanted to clarify it, and thereby the Supreme Court in the Shankari Prasad the Supreme Court in the Shankari Prasad versus the Union of India case, the Shankari Prasad versus the Union of India case, the Supreme Court interpreted Article 13 Clause 2. The Supreme Court interpreted Article 13 Clause 2, and the Supreme Court said that the Parliament of India has two kinds of legislative powers. One is the ordinary legislative power. One is the ordinary legislative power, and second is the constituent legislative power, under Article 368 of the Constitution. Further, the Supreme Court said that under Article 13 Clause 2, the term law that is mentioned, the term law refers to the laws made by or enactments done by the Parliament in exercise of its ordinary legislative powers, not in exercise of its constituent legislative powers, in exercise of its ordinary legislative powers. And therefore, the Parliament, under its exercising its ordinary legislative powers, cannot amend the Constitution. So the Parliament, if it is exercising its ordinary legislative powers, cannot amend the Constitution, including fundamental rights. Including fundamental rights, which means to amend fundamental rights, the Parliament would have to take up its constituent legislative powers that it has under Article 368, and by exercising whatever procedure and whatever power has been given to it under Article 368, the Parliament of India can amend any part of the Constitution, including fundamental rights, but only through a constitutional amendment, by exercising its constituent legislative powers, only through constitutional amendment. Clear? So the Supreme Court clarified what is meant by the term law under Article 13 Clause 2. So Article 13 Clause 2 says, yes, if there is a law which is contradictory to fundamental rights or it is not consistent with fundamental rights, it is to be declared unconstitutional. And the Supreme Court said the term law that has been mentioned under Article 13 Clause 2, it refers to the laws that are enacted by the Parliament by exercising its ordinary legislative powers and not exercising its constituent legislative powers. So when you exercise your constituent legislative powers, it is not, no, that is not what a law is. Law under Article 13 Clause 2 is an enactment that you make under Article 13 Clause 2 by exercising your ordinary legislative powers. In other words, if you remember, we did talk about something called as ordinary bill. And the Parliament cannot amend the Constitution by coming up with an ordinary bill. If you want to amend the fundamental rights or the Constitution, in that case, you have to use Constitutional Amendment Bill that is mentioned under Article 368 of the Constitution. Clear? However, this interpretation of the Supreme Court was available only in the Shankari Prasad case. Post Shankari Prasad case, the Supreme Court in the in a very very important case called as Golaknath versus the state of Punjab, 1967 case, the Supreme Court overruled its earlier decision and said that the Parliament of India exercises only one kind of legislative powers, not two kinds, only one kind of legislative power, that is ordinary legislative power. The Supreme Court went ahead and said that the power to amend the Constitution, including fundamental rights, is not there with the Parliament, and that is the reason why Article 368, the title of Article 368 is the procedure to amend the Parliament, and it does not mention the term power of the Parliament to amend the Constitution. Because it does not mention the term power of the parliament to amend the constitution, it means the Parliament of India has no legislative powers to amend the constitution, that is to amend even fundamental rights. The Parliament of India cannot amend fundamental rights. In fact, it cannot amend any part of the constitution. So the Golaknath case, in the Golaknath case, what did the Supreme Court do? In the Golaknath case, the Supreme Court took away, by interpreting the constitution, the Supreme Court took away the power of constitutional amendments, or it took away the constituent legislative powers of the Parliament, thereby simply meaning that the Parliament of India cannot amend fundamental rights. However, in reaction to the judicial pronouncement in the Golaknath case, the Parliament of India enacted something called as the 24th Constitutional Amendment. 24th Constitutional Amendment. What did the 24th Constitutional Amendment propose? The 24th Constitutional Amendment basically changed the title of Article 368, which was initially the procedure to amend the constitution. Now currently it reads the power of the Parliament and the procedure. Now, power of the Parliament to amend the constitution and the procedure therein. This is the title of Article 368 as of today. Why? Because it has been, this title was changed under under the 24th Constitutional Amendment, and now it reads the power of the Parliament and the procedure therein to amend the constitution. Similarly, the 24th Constitutional Amendment added Article 13 Clause 4 and also added Article 368 Clause 3. Article 13 Clause 4 read that nothing in this article should be applicable to an amendment made to the constitution under Article 368. And Article 368 Clause 3 read that nothing in Article 13 is applicable to an amendment made under Article 368, which means that by the 24th Constitutional Amendment that was taken up by the Parliament of India, they basically reinstated the 24th Constitutional Amendment, reinstated the power of the Parliament to amend the constitution, which was taken away by the Golaknath case in the Supreme Court. It was taken away in the Golaknath case, that was reinstated by the 24th Constitutional Amendment. Clear? Have you understood this? So the story is this. Initially in the Shankari Prasad case, 1951, the Supreme Court came out with a logical interpretation of Article 13 Clause 2. Article 13 Clause 2, wherein it says that law means an ordinary law that is passed through the exercise of an ordinary legislative power. It does not include the constituent legislative powers of the Parliament that has been given to it by the Article 368 of the Constitution. So if the Parliament passes a constitutional amendment under Article 368, it can amend any part of the Constitution, including fundamental rights. Now, what happened in 1967? Why is it that by 1960s the Supreme Court comes out with something called as in the Golaknath case, and what is the background of such interpretation? See, if we go back to the 1960s, after the death of Lal Bahadur Shastri and Indira Gandhi coming to power, the first thing that Indira Gandhi, once she was the Prime Minister of India, what she wanted to do was she wanted to consolidate power. Now she wanted to consolidate power. Why? Because initially Indira Gandhi was not next in line to become the Prime Minister of India. Indira Gandhi was not next in line after Lal Bahadur Shastri. In fact, even Lal Bahadur Shastri was not next in line to Jawaharlal Nehru to become the Prime Minister. It was Morarji Desai. It was always Morarji Desai. Morarji Desai was the, no, he was always the second in command when it came to the Congress. But the Congress party had a group within it called as the syndicate. The group which was led by K. Kamaraj, Tamil Nadu. He was a leader of Tamil Nadu and he was the one who was leading this syndicate. There were some other individuals also. So the syndicate wanted to enjoy power, but this power indirectly. And this was not possible if Morarji Desai became the Prime Minister of India, because he had that kind of a stature in the Congress party. So rather than Morarji Desai, they proposed the name of Lal Bahadur Shastri first, and after the death of Lal Bahadur Shastri, second was Indira Gandhi. It was the syndicate who proposed the name of Indira Gandhi. And Indira Gandhi became the Prime Minister of India in 1965. Once she became the Prime Minister, she understood to effectively take up the to effectively take up the reins of Congress. She had to do what? She had to defeat the syndicate. And how could she defeat the syndicate? She could defeat the syndicate by consolidating power within Congress. And this is what she started. And in the background of this consolidation of powers, she sometimes took certain steps which was not completely constitutional. It was not necessarily constitutional. It was not necessarily a step or something that was, completely, legal, morally also correct. And that is the reason why in 1967, later on you would find that 1967 is it is a landmark watershed time when it comes to Indian politics, because in 1967 there was the 4th general elections that was held, and in 1967, after the 4th general elections, the Congress party, which was able to retain the union, that is Lok Sabha, the Congress party gets majority, but out of there were around 16 states that were there, they lost more in almost 80% of the states that were there. The Congress party lost the state legislative assembly elections. The Congress party lost, and this was the time, 1967 was the time wherein in India you see the coming up of multi-party democracy. India was always a multi-party democracy. There was the Congress, then there was left parties, etc., etc. There were some other parties, some regional parties came into being. Then Jan Sangh was formed. Later on, this transformed into BJP. All these these ideas were there. But when you look at truly, when these political parties, these parties, except for the Congress, when they start exercising power, it was in the year 1967. And since 1967, the office of the governor, which you see, what is going on in Maharashtra, the office of the governor and the misuse of the office of the governor, it started in the year 1967 itself. The misuse of office of governor, the misuse of Article 356 of the Constitution, that is state emergency, all of this, it is a landmark event when it comes to Indian politics, 1967. And when the judiciary felt the need, when the judiciary felt the need to consolidate its power, or the judiciary felt the need, that there is a need to consolidate or to ensure that the judiciary remains independent of the executive, and the executive does not enjoy undue influence on the judiciary, the judiciary also, the Supreme Court also started coming up with certain judgments, certain judgments which were which was not necessarily something that has been mentioned in the Constitution, the manner in which it has been mentioned in the Constitution. And Golaknath case is an example of it. The Golaknath case is an example of it. आप कैसे कह सकते हो कि पार्लियामेंट के पास पावर नहीं है कॉन्स्टिट्यूशन को अमेंड करने के लिए? हाउ कैन यू से दैट? इट हैज बीन मेंशन्ड इन द कॉन्स्टिट्यूशन. कॉन्स्टिट्यूशन में लिखा हुआ है बाय 2/3 मेजॉरिटी एंड द मेजॉरिटी ऑफ द टोटल मेंबरशिप. इट हैज बीन मेंशन्ड इन द कॉन्स्टिट्यूशन. देखो, सुप्रीम कोर्ट इन द गोलकनाथ केस ओवरलुक्ड दिस आइडिया, और उन्होंने बोला टाइटल में क्योंकि ये लिखा हुआ है दैट it is only the what you can say, procedure and not the power, and hence the parliament does not have the power to amend the constitution. So the Supreme Court, or basically the judiciary during the late 1960s, 1970s, 1980s, this was the time wherein the judiciary was fighting to maintain its independence. Fighting to maintain its independence. Why? Because the political parties that were enjoying, the political party that was enjoying power at the union level, they had unquestioned authority. You can see Jawaharlal Nehru, Indira Gandhi, Rajiv Gandhi. In between, Janata Party came to power, but for 2 years not much of a difference. Rajiv Gandhi till 1989, that is 1947, or if you look at the constitution, 1950 to 1989, that is almost 40 years. In our constitutional history, you find a political party initially, it had a very consolidated, it was a very consolidated political party, and it was almost for a given that this political party is going to come to power. And in this particular arena, when the any political party or any political leader has that kind of support, when it comes to people, or for that matter when it comes to the legislature, you will find that these then they start taking up certain steps. Then they start taking up certain steps which may not necessarily be completely legal and moral, but it is definitely, you would definitely find that this kind of steps had political support. They will have political support. Popular opinion will be in favor of that kind of step, but it may not necessarily be completely moral. Like when it comes to Indira Gandhi, imposition of emergency. Imposition of emergency. It was something that had initially, if you look at the first 6 months of emergency, had political, it was popularly accepted by the people of India. After 6 months, that is when the problem started. Similarly, if you look at various steps of any government that has enjoyed popular support, like when we talk about Rajiv Gandhi coming to power, and Rajiv Gandhi also taking up certain steps, like Rajiv Gandhi proposing an amendment to the constitution called as the PRIs, Panchayati Raj institutions and municipal urban local bodies. It was Rajiv Gandhi who for the first time proposed amendment to the constitution, and Rajiv Gandhi proposed that the power to administer the PRIs, it should be there with the union government and not with the state government. But in the constitution, it has been mentioned that this power lies with the state government. But it had a popular, that idea had a popular support. So this is something that generally happens, and that is the reason why in the Golaknath case, the Supreme Court, trying to protect its independence by diluting the powers that the Parliament of India enjoyed, gave such a judgment. However, the 24th constitutional amendment, it made certain changes, reinstating the power of the Parliament when it came to its constituent legislative powers, that is the power to amend the constitution. Clear? Have you understood this idea? Now, before I go to the Keshav Nanda Bharti case, please write this. Yes.
Sir, so by this means 24 constitution.
देखो, अगर वो अनकॉन्स्टिट्यूशनल हो जाता अगर सुप्रीम कोर्ट ने उसे डिक्लेयर कर दिया होता, बट द सुप्रीम कोर्ट upheld the validity of the 24th constitutional amendment, thus in the Keshav Nanda Bharti case, but I am coming to that. Before that, you can write amendability of fundamental rights. Article 13 clause 2, Article 13 clause 2 says the state shall not make any law. The state shall not make any law that takes away one or more fundamental rights. One or more fundamental rights. If such a law is made, it is unconstitutional. If such a law is made, it is unconstitutional. The Supreme Court in the Shankari Prasad versus the Union of India 1951 case held that the Parliament enjoyed two kinds of legislative powers. First, the ordinary legislative powers, and second, the constituent legislative powers. Under Article 368. Any enactment of the Parliament made in exercise of its ordinary legislative powers is called law. Underline the term law. Is called law, which comes under the meaning of Article 13 Clause 2. Article 13 Clause 2. Therefore, the Parliament cannot amend the fundamental rights through exercise of its ordinary legislative powers. On the other hand, any enactment under Article 368 is called as Constitutional Amendment Act, and thus does not fall under the scope of Article 13 Clause 2. Therefore, the Parliament has the power to amend the Constitution under Article 368. Next paragraph. However, in the Golaknath versus the state of Punjab, 1967 case, the Supreme Court overruled its earlier decision and held that the Parliament enjoyed only one type of legislative power called the ordinary legislative power, and under Article 368, the Constitution merely contains, the Constitution merely contains the procedure to amend the Constitution, the procedure to amend the Constitution, and did not confer the power, and did not confer the power on the Parliament to amend the Constitution. Confer the power on the Parliament to amend the Constitution. Next paragraph. In response to the Golaknath case, in response to the Golaknath case, the Parliament enacted the 24th Constitutional Amendment, the 24th Constitutional Amendment, Amendment Act 1971, 1971, which introduced Article 13 Clause 4, which introduced Article 13 Clause 4, which reads, nothing in this article, nothing in this article shall apply to any amendment, made under Article 368, made under Article 368. It also changed the title of Article 368, the title of Article 368, which now reads, the power of the Parliament, to amend the Constitution and the procedure thereof, to amend the Constitution and the procedure thereof. It also introduced Article 368 Clause 3. It also introduced Article 368 Clause 3, which reads, nothing in Article 13 shall apply to an amendment made under Article 368. Article 368. Clear? So these were the three changes: 13 Clause 4, title of Article 368, and Article 368 Clause 3. The basic objective of it being reinstating the power of the Parliament when it comes to constitutional amendments. The Supreme Court in 1973, in one of the most famous cases of India's constitutional history, called as the Keshav Nanda Bharti versus the State of Kerala case, upheld the constitutional validity of the 24th Constitutional Amendment. See, देखो Supreme Court के पास choice था. If the Supreme Court wanted, the Supreme Court could have, declared this constitutional amendment to be null and void, and thereby depriving the Parliament of the power to amend the Constitution. However, the Supreme Court came out with a much more innovative expression, a much more innovative interpretation, wherein though it upheld the constitutional validity of the 24th Constitutional Amendment, said yes, the Parliament enjoys the power to amend the Constitution. It enjoys the power to amend any part of the constitution, including the fundamental rights, including the fundamental rights. However, this power of the parliament is, this power of the parliament is limited to the scope or to the extent of destroying the basic structure of the constitution. It came up with this particular idea in the Keshav Nanda Bharti case. Yes, the parliament has the power to amend any part of the constitution, including the fundamental rights, and this power, it is unlimited. It is not limited. You cannot say that this is what you can amend and this is what you cannot. No, the parliament has the power to amend any part of the constitution, including the fundamental rights. However, the Supreme Court says that this power is not unlimited. There is a limit to this power, and that limit that is there, it is by the means of something called as destroying the basic structure of the constitution. Destroying the basic structure of the constitution. Now, what is basic structure? The Supreme Court did not define what is basic structure. The Supreme Court does not define, even till today. In various cases, the Supreme Court from time to time has declared various aspects of the constitution to be various philosophy, various principles to be the part of basic structure. But even today, the Supreme Court has not defined what is the meaning of basic structure. However, for our purposes, what is basic structure? Basic structure means certain basic pillars of our constitution, which basically deals with the basic philosophy of the constitution. And the Supreme Court from time to time has declared that various aspects like supremacy of the constitution, sovereignty of the country, welfare state, secularism, democracy, parliamentary form of government, free and fair elections, republican form of government, judicial review, rule of law, federation, balance among the three organs of the state, balance between part 3 and part 4 of the constitution, fundamental rights given under 14, 15, 19, 21, etc. These are all the part of basic structure of the constitution. But what is the exact technical definition of basic structure has not been given by the Supreme Court. For our purpose, if we need to understand what is basic structure, so it simply means if we look at the various decisions that the Supreme Court has given, and in that various decisions, when the Supreme Court has declared some provisions to be the part of basic structure, if we look at that and if we try and deduce what is the meaning of basic structure, we will deduce that basic structure is something which is like a basic pillar, a basic philosophy of our constitution, and if that pillar or basic philosophy is changed, our constitution may not have the same meaning that we see as of today. And that is what we can see as the definition of basic structure. So the Supreme Court, in the Keshav Nanda Bharti case, by giving this idea of by giving this doctrine of basic structure, the Supreme Court did what? It limited the power of the parliament as to what the parliament can amend, and to what extent the parliament can amend the constitution. But interestingly, the Supreme Court, it actually empowered itself rather than empowering the parliament. It empowered itself that from time to time, if any particular amendment to the constitution, the Supreme Court finds that this is an amendment which may not necessarily be, it may not necessarily be correct legally or otherwise, the Supreme Court empowered itself to ensure that it has the power to limit what the parliament can amend when it comes to the constitution. Thereby it came up with the basic structure principle. What you have to remember is that the the Supreme Court says destroying the basic structure, which means can the provisions which are the part of basic structure, can it be amended? Yes, it can be amended. What cannot happen is it cannot be destroyed. What is the meaning of destruction? You cannot amend the constitution in such a manner that it nowhere it anymore carries the same principle or the same philosophy. You cannot destroy that. Yes, the parliament can amend the constitution. The parliament can amend the various provisions of the constitution, but the parliament cannot destroy the basic structure. It cannot destroy the basic structure. And this was the decision that was given by the Supreme Court. But again, Indira Gandhi was the Prime Minister when the Supreme Court came out with this decision, 1973. So she passed something called as the 42nd Constitutional Amendment Act in 1976, which again changed the provisions of the constitution by adding Article 368 clause 4 and Article 368 clause 5. Article 368 clause 4 and 5 was basically related to two ideas. First of all, Article 368 clause 4 wanted that there should not be any limit to the power of the parliament to amend the constitution. So this basic structure provision that was given by the Supreme Court, by this particular amendment, the parliament wanted to do what? The parliament wanted to come out with a provision so that it makes this decision of basic structure null and void. And hence Article 368 clause 4 now read that there will be no limit to the power of the parliament to amend the constitution. And Article 368 clause 5 read that any such amendment made by the parliament will not be or shall not be called into the question in any court of law, thereby depriving the Supreme Court or the judiciary of the power of judicial review. However, the Supreme Court in the Minerva Mills versus the Union of India case, the Supreme Court declared that the changes that were made by the 42nd Constitutional Amendment in Article 368, that is addition of Article 368 clause 4 and clause 5, it was held to be unconstitutional. And the Supreme Court declared that such powers cannot be taken away by the Supreme Court. The power of judicial review cannot be taken away by the parliament. It is the part of basic structure of the constitution. In the Keshav Nanda Bharati case itself, the Supreme Court had declared judicial review being the part of basic structure of the constitution. In the Minerva Mills case, the Supreme Court repeated its view, wherein it said that the power of judicial review is a part of basic structure of the constitution, hence it cannot be taken away. Clear? So these two provisions, the changes that were made by the 42nd Constitutional Amendment, it was declared to be null and void. So if you look at the current position is, can fundamental rights be amended? Yes, fundamental rights can be amended. But fundamental rights can be amended in such a manner so that it does not destroy the basic structure of the constitution. So that it does not destroy the basic structure of the constitution. Clear? And over a period of time, already we have seen Supreme Court has declared Article 14, Article 15, Article 19 and Article 21 of the Constitution to be the part of basic structure. So we cannot remove Article 14 or for that matter Article 15 or Article 19 or Article 21. These cannot be removed from the Constitution. So otherwise, all the other articles that you see, yes, it can be amended, but not in a manner that the Supreme Court feels that it is not correct. Simple meaning yahi hai, that it is completely up to the Supreme Court what amendments are to be declared to be valid and what amendments are to be declared to be null and void. Now it is completely up to the Supreme Court. Clear? Have you understood this? देखो एक interpretation इसका ये भी है. You have seen, I have just mentioned, in our discussion I have mentioned that balance between part 3 and part 4 of the constitution is considered to be the part of basic structure. Now what is part 3? Fundamental rights. What is part 4? Directive principles. Clear? So directive principles and fundamental rights. There should be a balance between how we exercise the rights that we have under article or under part 3 of the constitution and part 4, which means there should also be, there should also be the state. The state is also implementing directive principles, the directives that it has been given under the constitution, and there is a balance between them, which means in certain cases you would find that the court from time to time does what? Comes out with various interpretations. Like in any case the Supreme Court might say that this provision is, this might be wrong. Like let's understand this through an example. If I ask you a simple question, Article 19 of the Constitution provides us the power of what you can say, following an occupation of our own choice. It gives us that fundamental right, any occupation that you want, obviously with certain terms and conditions. If I am not a doctor, I cannot practice medicine, obviously. So there are certain terms and conditions that are imposed, but along with that, I enjoy that fundamental right. Now if I ask you a question, do I have the right to, suppose, open an alcohol shop? Is it my fundamental right? Because Article 19 provides us the right to choose an occupation of my own choice. Now tomorrow if I want that, I go in a particular place and I start selling alcohol. Can I do that? No, I cannot. Why? This shows the very balance that we are talking about. I have the right to occupation and hence I can choose. It is something that is up to me. But it is that right that I am talking about. There needs to be a balance between part 3 and part 4. What is part 4? Part 4 of the Constitution, specifically in directive principles, when we come to directive principles, you would find that it says that the state has the responsibility, it is a directive that has been given to the state to ensure the health of the people, the health of citizens of India, and thereby the state regulates when it comes to selling of intoxicants, etc., etc. The state regulates it. In fact, if you have been going through the newspapers, very recently you must have come across a news wherein in the state of MP they are trying to legalize this cannabis or farming of opium and this. They are trying to legalize it. Karena. Now this is something that the state might do this, but the judiciary would do what? The judiciary might give certain directives to the state how you can implement this. ऐसा नहीं है कि large scale, क्योंकि it's very productive in terms of the economic value that is attached to it. तो ऐसा नहीं होगा कि लोग ने एग्रीकल्चर छोड़ के और शुरू कर दिया ये गांजा और ये सारी चीजें ये करना. That the state cannot do. Such regulations that the state comes out with, the judiciary might give certain directives to the state how you can implement it. Clear? A balance between part 3 and part 4. And similarly, when we talk about later on, when we come to Article 15 and Article 16, we are going to talk about something called as 10% reservation to economically weaker section. Have you ever thought, why only 10%? Why only 10%? Because if you look at the economically weaker section, in India there are various committees and commissions which say that in India 22% of the population are poor. 22% of the population are poor. When you are giving reservation to scheduled caste, scheduled tribe, you give them on the basis of their population. When you give reservation to other backward classes, so there is a limit that has been decided, a logical limit, okay, 27% or something like that. There has been a law. Then why only 10% for economically backward section? Why not just extend it to 25% or make it 20%? Because then the balance between part 3 and part 4 of the constitution somehow gets disturbed. And then the Supreme Court, the Supreme Court has not, this has been challenged in the Supreme Court, and the Supreme Court has refrained from giving any such decisions here. The hearings are still going on. But if you would have given, if the state would have come out with any such provisions wherein it declares such kind of reservation or something like that, in that case the Supreme Court would declare it null and void on such grounds. This week itself the Supreme Court has come out with a decision wherein it says that ये जो आप 80% reservation देते हो, ये बिल्कुल, it is unconstitutional. The Supreme Court has declared that. In Chhattisgarh very recently someone was saying to me that कुछ ऐसे services है जिसमें 82% reservation है. In certain cases in state of Maharashtra it has been included, it has been now it is 67%, something like that. Now this is not something that is constitutional. Similarly, from various provisions like the idea of democracy in India, the idea of democracy is a part of basic structure. You cannot tamper with this. No, you cannot tamper with this. तो कितने भी अरविंद केजरीवाल बोल लेंगे कि अब जो अगली बार अगर नरेंद्र मोदी जीत जाते हैं तो डेमोक्रेसी खत्म हो जाएगा, ये सब बेकार की बात है, ये कभी नहीं हो सकता. In India, this cannot happen. There is existence of Supreme Court, and they do what on the basic on these basic ideas which has been declared. Democracy is a part of basic structure, and any government, whichever government comes to power, if it tampers with the idea of democracy, those steps by the executive or by the legislature are to be declared as unconstitutional. Similarly, we have also come up with this idea, parliamentary form of government to be the part of basic structure, which means the current legislative mechanism that is there, the idea that is we will not be able to change this. It's very unlikely that we change this and we move towards a presidential system. That will not happen. Republican form of government, that means elected head of the state. ठीक है, elected head of the state. तो कल को ऐसा नहीं होगा कि if the Congress party somehow decides कि चलो कोई नहीं तो गांधी परिवार में से सब उनको बना देते हैं प्रेसिडेंट, हेरिडिटरी रहेगा वो, ठीक है, उनको अगर मौका मिलता ना कर भी देते हैं, बट that will never happen. Why? Because Republican form of government is a part of basic structure of the constitution. So something that has been declared as a part of basic structure of the constitution, the Supreme Court says you cannot tamper with it. You cannot tamper with it. Clear? So along with the doctrine of eclipse idea that we were discussing, wherein doctrine of eclipse was considered to be, I said it was an innovative interpretation by the Supreme Court of Article 13 of the Constitution. Similarly, the power to amend the Constitution or the fundamental rights, when it comes to the power to amend the fundamental rights, does the Parliament have the power to amend the Constitution and the fundamental rights? Yes, they have, but they cannot do what? They cannot destroy the basic structure of the Constitution. Clear? So again, an innovative interpretation of the Constitution, an innovative innovative application of when it comes to the jurisprudence, when it by the Supreme Court in India, thereby putting certain limitation, logical limitations on the power of the Parliament when it comes to amending the Constitution, including fundamental rights. Clear? Write this down. The Supreme Court in the Keshav Nanda Bharti case, in the Keshav Nanda Bharti versus the state of Kerala, 1973 case, upheld the constitutional validity, upheld the constitutional validity of the 24th constitutional amendment, of the 24th constitutional amendment, and ruled that the parliament enjoys constituent legislative powers under Article 368 to amend any part of the constitution, including fundamental rights, the court further stated that such powers are not unlimited and are limited to the extent of not destroying the basic structure of the constitution. The doctrine of basic structure is a judicial innovation and has not been explicitly mentioned in the constitution. The Supreme Court has also not defined what is the meaning of basic structure. However, in various cases, the Supreme Court has declared the following. To be the part of basic structure. Either you can write point wise or in the manner you want. First, supremacy of the constitution. Second, sovereignty of the country. Third, the mandate to build a welfare state. Fourth, secularism. Fifth, democracy. Sixth, parliamentary form of government. Seventh, republican form of government. Eighth, judicial review. Ninth, rule of law. 10th, free and fair elections. free and fair elections. 11th, balance between three organs of the state. Balance between three organs of the state. 12th, balance between part 3 and part 4. Balance between part 3 and part 4 of the Constitution. 13th, fundamental rights under Article 14. Fundamental rights under Article 14, 15, 19 and 21, etc. Next paragraph. The Parliament enacted the 42nd Constitutional Amendment. The 42nd Constitutional Amendment in 1976, which introduced Article 368 Clause 4 and Article 368 Clause 5. 368 Clause 4 read, no amendments to this Constitution, no amendments to this Constitution shall be called in question, or challenged before any court of law. Any court of law. Article 368 Clause 5. Article 368 Clause 5 stated that there shall be no limit. There shall be no limit to the constituent legislative power, of the Parliament, However, both these provisions were held to be unconstitutional and void, in the Minerva Mills versus the Union of India 1980 case. 1980 case. Clear? So this is the evolution of this idea whether the Parliament can amend fundamental rights or not. Clear? Now, the next topic that we discuss is suspension of fundamental rights. So give a subheading, right? Suspension of fundamental rights. Suspension of fundamental rights. See, suspension of fundamental rights has been mentioned under two provisions of the Constitution, Article 358 and Article 359. Article 358 and Article 359, these are the two provisions, two articles of our Constitution which deals with suspension of fundamental rights. So when can the fundamental rights be suspended? Fundamental rights can be suspended only when an emergency is in place under Article 352 of the Constitution. So Article 352 of the Constitution deals with something called as national emergency. It deals with national emergency, and only during this period, that is when national emergency has been proclaimed by the President, only then fundamental rights can be suspended. Fundamental rights cannot be suspended if there is a state emergency or President's rule in place. No, it cannot. It cannot. Only during the proclamation of national emergency, fundamental rights can be suspended. Otherwise, it cannot be suspended. In nowhere, in no other case, fundamental rights can be suspended. Clear? National emergency under Article 352 is proclaimed on 3 grounds. What are those grounds? War, external aggression, and armed rebellion. Clear? Only on these 3 grounds the national emergency can be proclaimed. Clear? So when if there is a condition wherein there is a declared war between India and any other country, or there is an external aggression from any other country, or there is an armed rebellion within the country, only in these 3 cases the cabinet, the union cabinet, on a written recommendation given to the President, if the President is satisfied, the President does what? The President proclaims national emergency. If emergency is declared on the grounds of war and external aggression, it is called as external emergency. And if it is because of armed rebellion, it is internal emergency. If it is on the grounds of war and external aggression, it is external emergency. If it is on the grounds of armed rebellion, then it is internal emergency. Article 358 says, if emergency has been declared on external grounds, that means because of war and external aggression, in that case Article 19 of the Constitution is automatically suspended. If emergency has been declared on the external grounds, that means in case of war and external aggression, in that case emergency, or if that is the reason for emergency, in that case Article 19 of the Constitution gets automatically suspended. It gets automatically suspended. The President does not have to suspend it. It gets automatically suspended. Clear? Article 359 says that if national emergency is in place, that means on any grounds, it may be because of war, external aggression, or even armed rebellion, which means in case emergency has been declared on external or internal grounds, national emergency has been declared, in that case through a separate proclamation, the President can suspend the enforceability of one or more fundamental rights except Article 20 and 21 of the Constitution. Except Article 20 and 21 of the Constitution. So if national emergency has been declared, on the grounds that is external, that is war or external aggression, in that case Article 19 of the Constitution gets automatically suspended. Whereas if national emergency is declared on whatever grounds, that is out of the three, on whatever grounds if national emergency has been declared, in that case the President through a separate proclamation can suspend the enforceability of one or more fundamental rights except for Article 20 and 21 of the Constitution. Except for Article 20 and 21 of the Constitution. Clear? Now, why not Article 20 and 21? First of all, this was an amendment that was made to the Constitution by the 44th Constitutional Amendment. That means suspension of fundamental rights and not suspending the enforceability of Article 20 and 21, it was added to the Constitution by the 44th Constitutional Amendment. Before that, it said that enforceability of one or more fundamental rights can be suspended. It did not say except Article 20 and 21. That was not what was the part of original Constitution. It was added in 1978 by the 44th Constitutional Amendment. Obviously, the reason was very clear. National emergency 1975 से 77 तक हमने देखा था. National emergency, we actually saw the consequences of national emergency, and because of that, so that it is not politically misused ever in the future, the Article 352 of the Constitution was significantly amended. What were the amendments? I will be talking about that later on when I discuss emergency. Right now, what you need to know is this amendment, that is that fundamental rights that are mentioned under Article 20 and 21, it cannot be suspended, was added by the 44th Constitutional Amendment. Article 21 of the Constitution simply says right to life and personal liberty. So an individual cannot be deprived of his right to life and liberty just because there is a national emergency. तो जिस तरीके के अरेस्ट्स हुए थे 1975 onwards till the emergency, that provision is no more there. That is absolutely over. That is no more there. No one can be detained without proper what you can say legal detention. Legal detention is allowed. Illegal detention is not allowed. No one can be deprived of their right to life and personal liberty. Secondly, Article 20 of the Constitution also also provides us with some kind of freedom. Now, it also provides us with certain kinds of freedom. Now, like it is basically freedom from detention, certain kinds of detention. I will be talking about it later on. Now, it talks about certain kinds of laws that are made, etc., etc. But forget about it for right now. Just learn it as a fact that Article 20 and 21 of the Constitution, we cannot be deprived of Article 20 and 21 of the Constitution despite the fact that there is national emergency that is in existence. Clear? Clear? Now, can Article 19 be suspended under Article 359? Yes, it can be. So if you get a statement, just so that you are absolutely clear, if you get a statement, the statement says that if an emergency under Article 352 which has been declared on internal grounds or because of armed rebellion, Article 19 of the Constitution cannot be suspended. It is wrong. It can be suspended, the enforceability of it can be suspended, but it is not automatically suspended. This is what is the only difference. Clear? So Article 358 says, if suppose emergency has been declared on the external grounds, in that case Article 19 gets automatically suspended. If emergency has been declared, national emergency has been declared, in that case by evoking Article 359 of the Constitution, the President can suspend the enforceability of one or more fundamental rights except for Article 20 and 21. Which means all the fundamental rights that has been given to us from Article 14 of the Constitution to Article 32 of the Constitution can be, the enforceability of it can be deprived. We can be deprived of it. Now, if you look at this particular, if you look at these two articles, I have specifically used two terms here. Under Article 358, I have said that it can be suspended. On the other hand, it is automatically suspended. And under Article 359, what did I say? The President can suspend the enforceability. I have not said that the President can suspend any fundamental right except Article 20 and 21. I have said the President can suspend the enforceability of fundamental rights except Article 20 and 21. Which means there is a difference between these two ideas. Suspending a fundamental right and suspending enforceability of a fundamental right are two different things. How can you understand this? By looking at it from an example. Through an example. Suppose national emergency has been declared on the grounds of war or external aggression, and Article 19 has been automatically suspended. In that case, if I have been deprived of my right to freedom of speech and expression, and if I approach the Supreme Court will say, which right? You don't have any fundamental right of Article 19. You don't have that right because emergency is there. Constitution says that this is suspended. The whole Article 19 is suspended. So the Supreme Court will not hear the matter at all because there is no fundamental right. It has been suspended. So we don't have a fundamental right. On the other hand, if emergency has been imposed on the grounds of national emergency and I have been deprived of suppose any of my other fundamental rights except for obviously Article 20 and 21, that cannot be there. It means the President has suspended the enforceability of it. So if I am deprived of it, if I go to the court, if I go to the Supreme Court would listen, it would hear the matter. It would hear the matter, it would just say that yes, you have been deprived of your fundamental rights, but the court can do nothing about it. Why? Because during this particular period, we cannot enforce fundamental rights. The Supreme Court will deny the enforcement of fundamental rights. It would accept the idea that yes, you have been deprived of your fundamental right, but it will do what? It will not enforce your fundamental rights. Article 32 makes it a duty of Supreme Court to enforce fundamental rights, which means technically speaking, for all those fundamental rights that are suspended under Article 359, what you do not have is Article 32, which means you cannot go to the Supreme Court and ask for enforcement of fundamental rights. You cannot do that because enforceability has been suspended. On one hand, you cannot approach the court at all because you don't have fundamental rights. On the other hand, in the second case, you will be denied of enforcement of fundamental rights. If you ask the court for enforceability, the court will deny that. This is the consequence is similar, but the manner in which the consequence is actually implemented are two different things. In this case, you do not have the fundamental right to freedom of speech and expression itself. In this case, you have the fundamental right to freedom of speech and expression, but if you are deprived of that right, the Supreme Court will not reinstate your right. समझ रहे हो? In this case, you do not have the fundamental right of freedom of speech and expression. You do not have the right itself. But in this case, you have the right. But if you are deprived of your right to fundamental speech and fundamental right to speech and expression, if you go to the court, the Supreme Court would refuse to enforce the right because the enforceability has been suspended. So if you enjoy it, it's fine. But if you are deprived, the Supreme Court will not reinstate the right. This is the meaning of these two ideas. Clear? Have you understood what is Article 358, 359? Okay? And remember, any of fundamental rights can be suspended, but Article 20 and 21 cannot be suspended. Article 19 can be suspended on all the grounds. That means it can be suspended because of external emergency. It can be suspended because of internal emergency. It is automatically suspended when external emergency is imposed. If internal emergency is imposed, in that case, automatic suspension is not done. President through a separate proclamation can suspend enforcement of those fundamental rights. Absolutely clear? Clear? अभी हाँ बोल रहे हो, मैं emergency के time पे फिर पूछूंगा. So I want the answers then. ठीक है ना? अभी तो ठीक है. Until unless you revise it, you will not be able to recall it then. ठीक है? So revise this. What you also need to understand is sometimes a question is asked which will point to this difference between Article 358 and Article 359. Let's understand this. Give this as a subheading, right? Difference between Article 358 and 359. Have you written this? इतना लिख लिया ना आपने? Okay. Difference between Article 358 and 359. You can write this. Article 358 applies. Article 358 applies only to external emergency. External emergency. While Article 359 is in case of external and internal emergency. External and internal emergency. Second point, Article 358 deals with suspension of Article 19 only. Article 19 only, whereas Article 359 deals with suspension of enforceability of one or more fundamental rights, except 20 and 21. Except Article 20 and 21. Third point, under Article 358, Article 19 is automatically suspended. Article 19 is automatically suspended. Whereas under Article 359, it is not automatically suspended. Not automatically suspended, but suspended through a separate proclamation. Suspended through a separate proclamation of the President. And the next point, under Article 358, the Union Executive does not enjoy any discretionary powers, whereas under Article 359, the Union Executive enjoys wide discretionary powers. The Union Executive enjoys wide discretionary powers to suspend, or not to suspend, enforceability of fundamental rights. And this is not just for suspension of fundamental rights, it is also to actually reinstate fundamental rights, the enforceability. It can be done under Article 359, but when it comes to Article 358, it is only to be reinstated when national emergency is no more there, or at least it is not there in case of external grounds. Only then it will be reinstated. Otherwise, it will remain suspended till the time national emergency is there. So Union Executive does not enjoy any discretionary powers under Article 358, but under Article 359 it does enjoy certain discretionary powers. Though I am saying Union Executive, but I do not mean the President. I mean basically the Council of Ministers headed by the Prime Minister. Clear? Now, coming to the last discussion before we get into Article 14 of the Constitution, it is called as judicial review. Judicial review of fundamental rights. Yes. What do you mean by, or what do we mean by judicial review? Can you give me an example of judicial review? What is meant by this idea of judicial review? Can you give me an example? आपने पढ़ा होगा. If you are going through the newspapers, if you have been reading the newspapers, you might have come across such examples.
There was a case regarding privacy which was included in Article 21.
In Article 21, right to privacy was included. Okay, that is an example of judicial review. Okay, anything else? Who enjoys the power of judicial review? The Supreme Court and the High Court. Yes, absolutely correct. Such powers are not given to the subordinate or lower judiciary. It is only there with the High Court and Supreme Court. So what is this power of judicial review? Judicial review simply means the power of the court, the power of the High Court and the Supreme Court to declare a law to be unconstitutional or void on the grounds that it is violating fundamental right, because we are discussing in the context of fundamental rights. Clear? So what is judicial review? The power of judicial review simply means the power of the High Court and the Supreme Court, not the subordinate judiciary. Lower judiciary के पास ये powers नहीं होते हैं. The power is there only with the Supreme Court and only with the High Court. The power of the High Court, the power of the Supreme Court to declare a law to be unconstitutional or void on the grounds that it is violating the provisions of the Constitution. In this context, it is when it is violating the fundamental rights. Like when we took up an example of when I said section 66A of the IT Act, that is an example of judicial review. The court looked into the law, found it to be violative of fundamental right under Article 19 of the Constitution, under Article 19(1)(a) to be more exact, and declared it to be unconstitutional and void. That is an example of judicial review. Clear? What is the objective of judicial review? The citizen should not be deprived of their fundamental rights. Anything else? Anything else? Enforceability of Article 142 of the Constitution. Do you think that is the objective of judicial review?
Limiting the powers of the Constitution.
Limiting the
Powers of the Constitution.
limiting the powers of the legislature.
Checks and balances.
Do you think limiting the power of the legislature is the objective of judicial review?
Any law, if it is any law is unlawful or it is depriving a citizen from fundamental rights, so judicial review will be there and they will make sure that it will not deprive the citizen.
See, depriving rights or depriving a citizen of of their fundamental rights. Yes, I have accepted that is one of the objectives of judicial review. Why are we following? Why have we given the power of judicial review to the courts? One of the reason is that so that people or so that the judiciary ensures that the citizens of citizens of India, they enjoy fundamental rights. Absolutely correct. Anything else? Okay, you said no. An example of judicial review is right to privacy and the Supreme Court's decision on right to privacy, ensuring or making privacy a fundamental right. Now, what has that led to? What is the consequence of the Supreme Court declaring suppose right to privacy or such rights to be a part of fundamental rights, or extending the scope of fundamental rights and including such ideas in the ambit of fundamental rights, in the scope of fundamental rights? What is the consequence of it? To protect democracy. Okay. Anything else? Anything else? When you say protecting democracy, don't you think separation of powers, ensuring separation of powers and the phenomena of checks and balances is also one of the reasons why we have judicial review? Do you think ensuring the prevalence of a limited government, I have explained this idea. What is a limited government? In fact, yesterday itself I had explained this idea of a limited government. Do you think prevalence or existence of a limited government, presence of a limited government is also an objective that is achieved by the phenomena of judicial review? By the phenomena of judicial review? Section 66A का example मैंने दिया ना. If the individual has expressed dissatisfaction with some of the provisions, that expression of dissatisfaction that is there and the consequence of it, the state arresting those individuals, do you think that is what limited government is? That we do not have the right to express dissatisfaction? No. When the Supreme Court declares the law to be unconstitutional, what does the Supreme Court lead to? It ensures that the Supreme Court has ensured that the executive stays within their limits and does not encroach upon the rights of the citizens. यही तो आपने कहा ना, fundamental rights. So encroachment of that right. When we say existence of fundamental rights, what did I say? Existence of fundamental rights ensure that we do not live under a totalitarian state, under an unlimited state, under an authoritative state, under an exploitative state. यही तो होता है ना limited government, existence of a limited government. So what does judicial review ensure? Judicial review ensures that there is presence of a limited government as well. On the point that it limits the power of legislature, no, it does not limit the power of legislature or the power of executive. It just ensures that such powers that the legislature and the executive enjoys, such powers are enjoyed through a constitutional mechanism and they do not become unconstitutional or extra constitutional. That should not be the case. How can judicial review limit the power of legislature? We talk about separation of powers. And if judiciary starts interfering with the legislature, that is violation of separation of powers. But that is not the objective of judicial review. Judicial review just ensures that the executive and the legislature discharge their constitutional responsibilities. And they do not enjoy whatever powers they have in such a manner that is extra constitutional or even illegal. Okay? So it's not a limitation on the power of executive and the judiciary till the time the powers that are enjoyed by the executive and the judiciary, they are enjoying such powers through a legal, through a constitutional mechanism. Judicial review comes into being only when it has to declare or something that a certain practice or a certain law which has violated fundamental rights or the constitution, then judicial review comes into being. Otherwise it is not there. Which means what? Which means only ensuring that any extra constitutional authority or certain arbitrary powers that the executive or the legislature may gain, such arbitrary powers are not exercised by the executive and the legislature. Clear? But the mechanism of judicial review, the manner in which it has been implemented in India, can also be questioned. Why? Because sometimes the judiciary has they have not stuck to the constitution and they have imposed their will or their authority in such a manner that it is also debatable. Like when we talk about the basic structure itself, where has the constitution where is the constitution talking about the basic structure principle? And because of it, this very provision can be misused by the judiciary. It can be misused by the judiciary to ensure not the supremacy of the constitution, rather the supremacy of judiciary. When you allow for the power of judicial review to such courts like Supreme Court and High Court, in that case it may so happen that we as citizens are not governed by the constitution, rather we are governed by the judiciary. Rather than being living in a phenomena or in a phase of rule of law, what we start living in is a phase of rule of judiciary. Judiciary, we are living in that particular, that may happen. And because of this, even when it comes to judicial review should also be exercised with caution. Judicial review should also be exercised with caution. And the Supreme Court has also come out with certain directives upon itself. In what cases will it exercise judicial review? And it says that there are three basic directives that it has given. First, if two interpretations of a law is possible, one interpretation makes it constitutional, the other interpretation makes it unconstitutional. the Supreme Court will always take the first interpretation which declares the law to be constitutional. Secondly, the Supreme Court will never take up a matter for judicial review suo moto. Suo moto means by itself. It will wait for a petition. Until unless a petition is filed in the Supreme Court will not take up, or for that matter the judiciary will not take up a matter for hearing. It does not take up suo moto applications by itself. It does not do that. And thirdly, it will review only a law which is enforceable. That means if there is a law in existence but it is not being enforced, the judiciary will not review that particular law. It will be left alone. Only when a law is being enforced, the judiciary is going to review it. These are certain limitations that have been imposed on by the judiciary on itself, so that the mechanism of judicial review, it does not lead to rule of judiciary. We live in an era which provides for rule of law and not rule of the judiciary. Clear? So these are certain certain things, certain limits that the judiciary has imposed on itself. The thing is that if you look at the negative consequences of judicial review, negative consequences of judicial review can be understood in two cases, or through two phenomena. Something called as judicial activism and something called as judicial overreach. You must have heard about these two terms, judicial activism. What is judicial activism? See, in judicial review, the Supreme Court just looks at the constitutional validity of an act. Law bana, executive has taken up an action, the Supreme Court or the High Court will look at it from the constitutional perspective, whether it is constitutional or not, whether the law is constitutional or not, whether the law is violative of fundamental rights or not, or whether the act done by the executive is violating fundamental rights or not. However, the judiciary does not offer suggestions to the executive or the legislature when it comes to judicial review. It only reviews the constitutional validity, does not go into this, that the act is unconstitutional and rather than doing this you should do this. That suggestions are not given by the judiciary. In judicial activism, the judiciary moves one step ahead and starts directing the legislature and executive as to what should be done. Rather than just looking at it from constitutional validity angle, in judicial activism, what happens is judiciary moves one step ahead and starts directing the executive. You should refrain from doing this. You should do this. Now this is something that in long term, if practiced in long term, can lead to complete destruction of separation of powers. When you start advising or when you start directing the executive and legislature, that is violation of separation of powers. Judicial activism is this. Judicial overreach is when the judiciary rather than goes one step ahead and starts assuming the role of legislature and executive. When the judiciary starts assuming the role of legislature or executive, it is defined as judicial overreach. Like going back to 14-15 in the state of UP, in the state of UP what happened was the Allahabad High Court, they had actually directed the Akhilesh Yadav government that was present to appoint a Lok Ayukt. Do you know who is a Lok Ayukt? It is a body like a Lokpal. I hope you know what is a Lokpal. जैसे लोकपाल पे सेंटर में होता है लोकपाल एक ऑर्गेनाइजेशन which looks into corruption etc etc. Similar kind of body is present at the state level also. That body is called as Lok Ayukt. और ठीक है, it can also be called as a state lokpal, a state lokpal. So in two of its decisions, in two of its directions, the Allahabad High Court actually directed the government of UP to appoint a Lok Ayukt. When the government of UP did not do it, in one of the decisions, there was a judge bench in the Allahabad High Court. They appointed Lok Ayukt by themselves. The judiciary appointed the Lok Ayukt for the state of UP. Now that is violation of separation of powers. You cannot do that. You cannot do that. That is something that is the jurisdiction of the executive. Appointments are done by the executive. The judiciary does not take up appointments. And when you do this, that is called as judicial overreach. That is judicial overreach. Clear? So these three terms, judicial review, judicial activism and judicial overreach, it should be very clear what it technically means. Judicial review, just looking at it from constitutional angle, and the objective of it is to ensure limited government, existence of a fair state, ensuring that the citizens enjoy their fundamental rights and other rights, ensuring that the steps taken by the executive and legislature, they are constitutional and not unconstitutional. These are the objectives of judicial review. The concept or the idea of judicial review has not explicitly been mentioned in our constitution. It is implicit under Article 13, under Article 32 and under Article 226 of the Constitution. It is implicitly present. Article 13 of the Constitution we have already discussed, supremacy of fundamental rights. Who ensures that? Judiciary. So judiciary takes up judicial review of laws and acts of the executive, looking at it from the constitutional angle. On the other hand, when we talk about, when we say Article 32, if you remember yesterday, out of the 6 fundamental rights, the last right that I mentioned was that right to constitutional remedies, and it has been mentioned under Article 32. Article 32 of the Constitution provides writ jurisdiction to the Supreme Court, and Article 226 of the Constitution provides writ jurisdiction of the High Court. And the power of judicial review is derived from writ jurisdiction. So any court which has the power to issue writs also has the power to has the power to take up judicial review. Only those courts which have writ jurisdiction has the power to take up judicial review. And that is the reason why we say subordinate courts do not enjoy such powers. Clear? This is what judicial review is. I will be taking up this later on as well. The idea of judicial review, from time to time I will be talking about this. So when we talk about an idea such as judicial activism or something like that, in that case you are going to write this phenomena. Clear? This is where we end today. Tomorrow when we meet, we start with our discussion on Article 14 of the Constitution. Thank you.